The broadcast is now starting. All attendees are in listen-only mode.
Welcome to today's webinar, everyone. I'm Anna Hobson from HR Simple, and I will be moderating today. Today we have Greg Grisham from Fisher Phillips presenting. If you do have any questions, please feel free to enter them in the question box, and we will get to them at the end of the webinar. If you would like to view more webinars, you can go to hrsimple.com/events, and we have all of our webinars posted there, as well as our partners like Fisher Phillips. There's some great resources on there, so I'd recommend you check it out. HR Simple provides federal and state-specific manuals. We make employment law easy. Our books are written by top labor attorneys and cover topics such as vacation policies, employee documentation, and how to fill out the I-9 form. You can go ahead and check out our resources at hrsimple.com/shop. So today's speaker is Greg Grisham of counsel in the Memphis office, and for 30 years he has successfully counseled and represented employers in all areas of labor and employment law. His practice includes all areas of labor and employment law, including helping employers avoid claims, charges, and lawsuits, with a focus on preventative practices and the representation of business entities subject to Title III of the American with Disabilities Act and public accommodation cases. So on that note, I'm going to hand things over to Greg so we can go ahead and get started.
All right. Well, very good, Anna. Thank you very much. It's always a pleasure to present for HR Simple. As Anna said, I'm with Fisher Phillips, and I've been practicing labor and employment law now for 32 years. And a big part of what I do is wage and hour cases, advising clients on wage and hour issues. They've been a big part of labor and employment litigation now for many years. It kind of exploded a few years ago, and so it just keeps growing. So, and now we have a lot of state laws. A lot of states have enacted their own laws, and even some localities. So it's very important for HR professionals and attorneys to understand and not only federal law but also state law. So today we're going to cover a number of things. These are things. One of the benefits of being with a national firm is we have offices all over the country, and we see issues that develop. Not only in states like California that has a tremendous amount of their own state law, but also Middle America and the East Coast, and so we see these issues popping up. So we're going to talk about some new issues. Independent contractors is always an important issue. Exempt versus non-exempt pay equity, remote work, record keeping, and off the clock and overtime issues. COVID-19, of course, changed the landscape for really all of us. I'll never forget back in March of last year, we all 425 attorneys at our firm, we all started working remotely, and our staff did too. Our paralegals and legal assistants, and so it was really interesting to make that transition. And of course now, most of us, at least, I think, are back in the office. We all enjoy working remotely when we need to. So we've all had to adapt to that. And we've had things come up when people have started going back in the office, or even when people were working on site during the worst part of COVID-19. About on-site temperature checks. People had to wait in line. Was that compensable time or not? What about classification? Should our classifications be altered because people's jobs became different somewhat when they were working remotely? So a lot of wage and hour issues presented. How do you keep up with time when someone's not on site? Time reporting. So there's a multitude of issues And so right now we're in a bit of a transition period as we get back to more normal type behavior in terms of our work life. So we'll have to see, how this plays out for the long term, whether it's going to be a long term, a short term change, or whether it'll be more of a longer term change. Hot areas of litigation, not properly reimbursing mileage. We do a lot of this litigation. We have represent companies that have delivery drivers. We do a lot of pizza cases, pizza delivery drivers. And so plaintiffs' attorneys are going after these people. There's a lot of advertising, a lot of attorneys that just really focus on this kind of litigation. So if you're in the business where you have delivery drivers, you need to, take notice. Wages must be paid free and clear. They have to, you have to pay. You can't, make deductions other than the authorized deductions in terms of, things are personal to the employee. The cases settle. A lot of these cases settle. I think most of them settle. And if depending on your situation, the settlements can be pretty high. So beware of this as an area of sort of a new and emerging area of litigation. Now, state laws. There are emerging state laws that deal with work use of personal devices. This is something that we're seeing pop up around the country. You also have state and local minimum wages rising. Now over half the states have minimum wages that are higher than the federal minimum wage, and you have a number of localities, cities, counties that have their own minimum wage. In Tennessee, we don't have a separate minimum wage. Localities aren't permitted to enact their own wage and hour laws. So we don't have that issue in Tennessee. And a lot of states, you don't see that, but you see more and more states increasing the wages. So it makes really the federal minimum wage, less important, where you have states all over the country that are increasing it. So this is definitely a trend, and I think it's going to continue. I mean, even Florida, states like Florida, we're doing it now. Currently, there are a few states: California, Iowa, New York, Massachusetts, Pennsylvania, Montana, and District of Columbia, and Illinois have laws that deal with reimbursement, reimbursing employees for using their personal devices at work. In California, statute, is one extreme. You have to reimburse employees for mandatory use if you knew they were using their personal devices for work or should have known. The other end of the spectrum is Illinois. They place the burden on the employee to notify the employer if they need a reimbursement. So if you have operations across the country, you need to be aware. If you're in any of these states, you need to make sure you're complying with this law. And we're seeing more and more states adopting various employment laws. Even last year, Tennessee adopted which I thought was good, a pregnancy accommodation statute. So even states like Tennessee, states in the South who haven't traditionally had a lot of state employment law are starting to enact these laws. All right, so we're looking at reimbursement laws. Let's talk about rounding. This comes up a lot. This has come up. In fact, I've got a case currently where rounding has come up, and they're trying to turn a case into a collective action because of an alleged rounding problem. So a lot of companies do it. Traditionally, you had people line up at time clocks, and everybody couldn't clock in exactly, at 8 o'clock, whenever they're supposed to be there. So companies adopted rounding, and there's nothing wrong with that. The Department of Labor has said that you can round to the 10th or even a quarter hour, but the only way you can do it is if the rounding doesn't have a negative effect on employees. So ideally, what you should have is over time, it's going to be a wash. Sometimes the employer will come out ahead. For example, if the employee clocks in at 4 minutes till 8, it rounds up to 8 o'clock. The employer benefits from that. The employee clocks in at 4 minutes after 8, 8:04. That would benefit the employee rounding back to 8. So if you do have rounding, you need to audit your process and make sure that what you're coming out with, is fair and neutral. It doesn't have to be exactly precisely even, but it should be, should come out over time, theoretically at least, practically, that you're going to sometimes the employee benefits, sometimes the employer benefits. So it kind of is a bit of a wash. This is a hot area of litigation. We've been doing a lot of advice with clients on rounding practices. Of course, I guess the most conservative thing you can do is just to, when they punch in, and so you pay based on that. So, but think if you do rounding, you'd make sure audit the process periodically to make sure that it's it's coming out right. All right, wage and hour risk and mitigation, an overview. What's driving the wage and hour litigation boom? Well, we see a lot of state law class actions. A lot of times you'll see a Fair Labor Standards Act collective action, and you'll add to that states that have wage and hour laws like California. You'll have a class action, a Rule 23 class action. They call those hybrid cases, which can be pretty expensive. But sometimes you'll have class actions that actually have employees from different states are involved in it. So we have the rise of state law has made these hybrid actions more common. I mean, even some states that don't have a lot of wage and hour law, you're seeing states that aren't really known for that or even having these. Misclassification is often at least one of the leading allegations in these cases. So we're going to talk about misclassification, working off the top claims where people claim that before they started, they clocked in, they did a certain amount of work. I've got a case right now where that's one of the really the main allegation is they work off the clock before they clocked in and after they clocked out. So a lot of those very common claim that you have. Plaintiffs attorneys, there are a lot of plaintiffs attorneys now that just specialize in wage and hour cases, and they understand that it's not that difficult to prove a violation because it is hard to comply with all the wage and hour laws, and even the best employers occasionally make a mistake. So you have people we have a firm here in Memphis that that's not all they do, but they do it all over the state of Tennessee. So every state has lawyers like that. Also, too, typically these wage and hour claims, what's dangerous for employers, particularly smaller employers, is they're not covered by insurance. And if they are covered by insurance, typically there's some limit on the policy, the policy amount. It's one sort of common thing that you see is they'll pay up to $100,000 for attorney's fees. And so, if you're a big employer, or even a middle-sized employer with operations in, around the country, that may not, be adequate to protect you. So it does pose danger to employers, these potential wage and hour class actions and collective actions that you find. Here's an example. California is always a good example to pull out because it's a lot of states are enacting laws similar to California, but they seem far and away the state with most state law type litigation. But here's an example pulled out. Some massive exposure, 2019 settlement. This is class action settlement of $130 million for a class of 14,000 security guards. So as you could see there, a big company like that with a lot of people doing the same kind of work, you're where there's not a lot of variation. In California too, with where you've got meal and rest periods, waiting time penalties, wage statements. You have a lot of landmines out there that you may comply perfectly with the Fair Labor Standards Act, but the state law I find will trip a lot of employers up. So that's a good example of the danger that's posed in these kind of cases. All right, mitigating the risk. Well, and you hear this all the time, and we say it all the time because it's true. You've got to have policies, written policies in place. For example, dealing with things like reporting time and getting approval for overtime, not working off the clock, complaining if your hours of work aren't correct or your paycheck's not correct. There are a number of things that you can do. So we have to have consistently compliant policies. Not only have the policies, but you got to, be consistent and also enforce them. One of the most difficult things, defending cases in general, or you have a client with policies and they're in writing, but they don't, enforce them, or at least enforce them consistently. So be aware of that. Also, arbitration agreements with class action waivers. This is a good way. The Supreme Court settled that question 3 years ago in the Epic case, where you can have class action waivers. They don't violate the National Labor Relations Act. You can have those, and that will at least protect you against these kinds of suits. Although plaintiffs' attorneys now, you see them sort of retaliating by having their clients file individual arbitration. So you have employers that are facing hundreds or thousands of individual arbitrations, which arbitration is a great way to go in a lot of situations, but it's also very expensive. So anyway, but they are a good way to at least deal with some of these risks. Now, wage and hour collective actions, class actions, collective actions, they've just continued to increase. 2020, although it was a difficult year with COVID-19 and litigation a lot of litigation slowed down considerably. 2020 had the highest level ever seen in the last 2 decades for plaintiffs getting conditional certification of wage and hour actions. And this is, it's the standard, at least in most circuits, is fairly easy to meet, at least for conditional certification. But you can see 84% were granted and 16% denied. Although there was an important case at the Fifth Circuit a number of months ago that said that there shouldn't be a lenient conditional certification standard. So we may see more circuits change their view on that. But anyway, and we're expecting, as the economy improves and people go back to work in 2021, we're already seeing it. You're going to see a lot more of these cases get filed. And now that we have a new administration in place, it's pretty clear that the Biden administration, the Biden Labor Department, is going to be much more stringent on enforcing the wage and hour laws. They're going to be more investigators, more audits. We're already seeing that around the country. So we could expect a lot more down the road this year. And also too, in the states, not just the federal Fair Labor Standards Act, but also the states. You had increases in minimum wages in 25 states this year. So the state law is going to continue to grow, and you'll see more and more state law type actions. All right, let's talk about independent contractor issues. This is a really important area. Um, the confusing thing about it is, under federal law, you have a lot of different federal statutes. You've got the Department of Labor, the wage and hour laws. You've got the NLRB, and and you have state law. So you've got potentially for an employer, not only just in one state, but if you're in multiple states, I mean, you can have multiple dealing with multiple statutes dealing with this type issue in different contexts. So, all in terms of independent contractors, I mean, there's a bias in favor of finding everybody to be an employee, and that really starts at the level of the government, who gets employers are tax collectors for the government, and so if you have employees, you're collecting, withholding, and you send that with ICs. It's a more difficult process, for the government, because you tend to lose out a lot of the people. There may not be great reporting, consistent reporting. So there's a bias in favor, and also too, independent contractors generally aren't covered by the labor employment laws. So there's a bias to try to find that people are employees, and the burden is really on the employer in these situations. Control seems to be the most important factor, although you typically have a number of criteria you look at, and there can be significant penalties if you misclassify somebody. I remember one of the first cases I had out of law school, as I represented a company, and they had these two or three employees, and they thought their accountant told them that they could make them independent contractors by having them sign an agreement to that effect. So they treated them that way, and they ended up getting sued by the Department of Labor. And the moral of that story is, you can't make somebody an independent contractor by having them sign a paper and say that they are. We'll talk about independent contractor agreements, but if somebody's really an employee, having them call themselves independent contractors, not going to hold up really anywhere. So misclassifying is a big problem. There are a lot of state law variations. California has this Dynamex and the ABC test, which is very hard. There are some exceptions, but it's hard for the hiring entity to show that somebody is an independent contractor. And they're the three tests listed in the PowerPoint. And it's very difficult to meet this. I mean, some people, if you have somebody who that's working for you like that, I mean, they have, under this test, they have to be free from control and direction of the hiring entity, and they have to perform work that's outside the usual course of your business. Which that's like calling, if you're a manufacturing company and you need some electrical work done, you call a contractor to come in. I mean, that would certainly meet the test, but having somebody working in your factory as an independent contractor on the production line would not cut it under this test. And also, the person has to be at an independent established trade, occupation, or business, like a tradesman of some type, electrician, plumber, carpenter, whatever. So anyway, this is a very difficult standard for employers to meet. There's still a lot of litigation over it. My state, Tennessee, and some other states have adopted it. And IRS has a number of different tests, but one is a 20-factor test the state uses to determine whether somebody's an employee under a number of the employment laws in the state. It's been around for about a year and a half, and it's a more lenient standard. It's easier to find someone to be an independent contractor, the more things you look at. So at least in Tennessee, in the states that have adopted it, you have more flexibility. But once again, that may fly and apply under state law if you have a recall to account under state law, but then you have federal law that you have to comply with, and if you have multiple operations in multiple states, and you have to really look at every state's law and find out where they are on it, because they're kind of all over the place. So differences, employers, independent contractors, a lot of employers use them to supplement their workforce, which, a lot of, I think at least most employers will, use a temp agency or something, which doesn't really raise these kinds of concerns ordinarily, because you're hiring an agency to provide workers. But, some employers do use independent contractors. Once again, there's hostility both at the state and federal government level for agencies about, making people independent contractors. So, from an employer's perspective, what do you gain from having an independent contractor? You don't have to do withholding, you don't have to pay benefits, no unemployment, no workers' comp. In other words, you save money. It's a huge cost savings for you. So I think that's, really what generally motivates employers to try to push people to be independent contractors. You also, you're not really covered by the employment laws, the wage and hour laws we're talking about. True independent contractor is not going to be subject to it. Title VII, you're not going to be responsible for, from a tort liability if they go do something ordinarily. And also, you may not have the same kind of immigration issues, although in Tennessee we have the Tennessee Lawful Employment Act, which also applies to independent contractors. So if you're using independent contractors, you have to make sure that they're, you can lawfully employ them in the U.S. They're lawful to work. And other states, I think, have that. Some other states have that as well. What are the cons from the worker's perspective, or the pros actually? Well, you can, work for a lot of different people. You can be your own boss. That's important to a lot of people. You see a lot of folks, driving for Uber and Lyft and working for these marketplace contractors, who advertise. And you just have more control over your life. The more you work, the more you make. You have control over profit and loss. So a lot of people, that appeals to a lot of people. They just prefer to be their own boss and not be restricted. The cons of independent contractor status from the employer's perspective. You have less control over how the work is done, although you can certainly insist on a particular kind of outcome. The independent contractor, if you have someone who's in demand, now, for example, if you're looking for contractors, they're very busy building houses because there's a bit of a housing shortage in a lot of places. So you may have trouble with scheduling and whatnot. You may have, they may be subject to be exposed to your trade secrets and things of that nature, which means you need to have some agreements if you're going to hire independent contractors. What are the cons from the worker's perspective? Well, there's less job security. You got to pay your own taxes. Self-employment taxes are pretty steep. Have benefits. Recently, in the last year, the CARES Act helped self-employed people with unemployment insurance benefits, which and you're seeing a lot of states actually. In our firm, we have a gig economy practice group where we have articles, and I've written several, which are kind of interesting. So I think there's a move around the country, at least in some states, and New Jersey is one of them, and I think New York too, to extend the employment laws, at least some of them, to independent contractors, and even there's a move to give them the right to organize. So I think you're going to see more and more of that, a move toward that, and this year, in the coming years. So there are pros and cons. There has been an increase in independent contractors in the last several years. And at least one study estimates that 10 to 15% of employers misclassify at least one worker as an independent contractor. So think about if you're a company that uses independent contractors, you need to kind of go over and make sure they truly are independent contractors, because there is a lot of potential exposure just given the different laws you have to comply with. Right. So you've got, once again, misclassification can lead to significant liability. You've got, if they are, misclassification cases are pretty big under the Fair Labor Standards Act. If they're misclassified, you have to pay overtime. So liquidated damages, attorney's fees. So it can get very expensive, particularly since you don't have great insurance for these kinds of cases. More problems. Once again, if you're supposed to have withheld taxes and you haven't, you're subject to liability, fees and fines and whatnot, in terms of the employer part of the payroll taxes that you should have withheld, and also, benefits too, that the employee should have been entitled to. So here's a question, see if everybody's paying attention. If you have a worker and company that both agree in writing, they have a written agreement that the worker's an independent contractor, can that status be challenged? Or is it true that that status cannot be challenged? What's the answer to that question? Well, the answer is false, because, while, we always encourage our clients to have an formal independent contractor agreement, which goes through and sets out, the nature of the relationship very clearly. I've done a number of those for clients. It doesn't shield you. You actually have to live it out. You have to operate, deal with that person as if they are an independent contractor. Because certainly if you get sued, the government comes, they're going to sort of look behind the agreement and look at what really happened. So it's very, very important to have a written agreement, and also know what state you're in, know what the state law is, know what the federal law is, so it can be designed appropriately. And there's no silver bullet to protect you from a suit here, but if you have a properly prepared agreement, and the person is really an independent contractor, it goes a long way to protect you down the road if you get sued. Economic realities test. This is a test that the U.S. Supreme Court has applied, for years, going back to 1947. And it literally looks at 5 things. This is what typically gets looked at when you get into wage and hour suits on misclassification, whether someone's an IC or or they're an employee. And the degree of control is always really top of the list. You look and see if the person had an opportunity for profit or loss. For example, can they go and work elsewhere? That they have autonomy. Do they make investments? Does the employee make investments in tools? They have their own tools, or does the employer provide everything? That's important. Is this an unskilled job? Is it a skilled job? Unskilled type labor tends to really point toward the person being an employee versus an independent contractor. Even though someone's skilled, that doesn't necessarily mean they're an independent contractor, but that's a positive in that regard, since most people do have particular skills. And you look and see the permanency of the relationship. Ideally, if my roof needs repairing, I'll call up, the roofer, and they'll come out and repair it. We don't have a permanent relationship. I just call them when I need them. If you have someone who's working for you every day, sometimes you have contractors that are there for a while to, do some type of project, but the permanency of the relationship is something that's very important that courts always look at. Now, NLRB, this was a pretty significant case back in 2019, the Super Shuttle case. This overruled, you'll see a lot of this coming up as President Biden appoints new members of the Labor Board, where the new Labor Board overrules, the last administration's labor board. It's just been going back and forth like that for years. But the Trump NLRB reaffirmed the traditional common law test and overruled the Obama NLRB's decision in 2014. This made it more likely, that employees would be found to be independent contractors. So this is an area I expect to see shifting, starting probably, it just depends on when they get a case, but I would say probably one of the Republican board members, Republicans have a 3-1 majority right now. I think you're going to see things start to change late in the year and into next year. It'll just sort of keep going until the next election. If the next election, the current administration gets reelected, you'll see it continue for another 4 years. So this is an important change in the law. The DOL had announced back in January the final rule of independent contractor status. This was going to, make it easier for employers to utilize people as independent contractors. But President Biden, when he came in, froze the regulation, and it was supposed to go into effect in March. It got frozen, and now it's withdrawn. As of May 6th, it got withdrawn. So we're not going to see that one. They may come out with another one or go back to what they had before. I recall in 2015, the Wage and Hour Administrator under President Obama had issued a memorandum which really emphasized how pretty much everybody's an employee. It was very pretty cut and dry. It seemed to make it very difficult for people to be into contractors. And the Trump labor board, the Trump DOL was trying to move it back, and so now I think it falls back on really what it's been, which is really the economics reality test that we talked about. How does misclassification come to light? Well, of course, if you get sued, if you wake up and one day and there's a process server at your door, then you've been sued, then you know that you got a potential problem at least. Department of Labor knocks on your door, you get an inquiry from the IRS or some taxing authority. Also, employees can complain internally about it, or you might get a letter from a lawyer. So there are any number of ways that you can be put on notice. At least you need to look into it. Choosing the correct form of the relationship, if it's something for a short period, a longer period. If it's a short period of time, an independent contractor situation may make more sense. Cost reduction needs, it's certainly cheaper to use an independent contractor, but you can't really convert. It's difficult to convert your employees into independent contractors if they're just doing the same thing. You call them something different, that's not going to usually not going to fly. So be very careful about it. It's certainly, I think, important to consult with a labor attorney who practices in the area, get some advice if you're thinking about reclassifying people. Or also too to go and look and make sure that your classifications are working, particularly after COVID-19. We've done a lot of work with clients where we go and do audits and make sure that, given all the changes that occurred during the COVID-19 pandemic, at least, are these people still properly classified as exempt? You have to look and see what they've been doing. It's always really focused on what they've been doing, as long as the salary basis test gets met where it's required. So choosing the correct form. What do? If you want to hire someone as an independent contractor, classify somebody, you got to make sure they have their own insurance, their own licenses, certifications. They have their own entity. They're or an LLC or incorporated. A lot of folks don't go to the trouble of doing it. They just have their own business. It's always wise to deal with people that have some entity there. It just the optics of it look a lot better. Memorialize a relationship. As we talked about a moment ago, you should go ahead and have an agreement with your independent contractor, and you want to make sure that um, um, that the worker's free to determine his own schedule and how the work's performed. That's a big factor that courts look at. It needs to be very clear, descriptive, and track all the items that the courts look at, and make sure that the agreement points to the person being an independent contractor. And then once you have the agreement, both parties have to sort of live it out, in a transparent way. It can't be some subterfuge for just trying to camouflage someone as being a independent contractor when they're really an employee. These are some other things you need to deal with. One thing that I do a lot of non-compete trade secret cases, and one thing you want to make sure in the independent contractor agreement is you address restrictive covenants, trade secrets, particularly trade secrets if they're working. If you have some IT uh, independent contractors working for you, you want to make sure that they're not, your trade secrets aren't being compromised. And also arbitration is always good to consider at least having an arbitration agreement in their provision too. All right, so audit, avoid exposure for misclassification. What do you need to do? Well, it's always good. I mean, a lot of companies, a lot of my clients use temporary employees from a staffing firm, and they sort of use it to vet the employees, temporary employees, and they'll offer them jobs if they turn out to be good. Once you can have a written agreement with the contractors, make sure they have their own employer identification number or a separate business entity, and make sure that the contractor provides their own equipment, and proves to you that they have insurance. Depending on, you want to make sure that people have insurance, because that's obviously a real problem if something happens. So exempt or non-exempt, let's talk about that. The default position under the Fair Labor Standards Act of people are non-exempt. So if people are non-exempt, you have to pay them time and a half for any hours over 40 in a work week. But there are several exemptions. There are some that are more common than others. You have to read the Fair Labor Standards Act pretty carefully, because there are a number of other exemptions. For example, like the motor carrier exemption, the retail service exemption, 7I. The ones we're going to talk about today really are just the main ones that you see, but there are a lot of others. So once again, what do we look at? We look at, are they paid on a salary basis, salary level threshold is met, and their duties. Those are the three main things that you look at. Not all these exemptions you have to pay on a salary basis, like the outside sales people. But those are the main things you look at. And the white collar exemption, we'll call them white collar exemptions. That's what they're referred to. Back in 2004, there was a change. It was increased. It had been very, very low for a long time. It went up to $455 per week. Then, of course, we had efforts in 2016 to increase it significantly. They ended up getting struck down by a federal judge, and so that didn't go anywhere. And the Trump administration came back, increased it to an annualized basis of $35,368, which went into effect last January. So you got to, where you have a salary basis requirement, you've got to pay them at least that much. Now, a few days ago, the new Secretary of Labor, Walsh, was testifying in front of Congress and says he thinks that the current number is too low. In fact, some members of the House were pushing for an $80,000 threshold, which would be over 2.5 times the current where the current threshold is. So expect some activity there. I would not be surprised. It may not happen this year, but I would think probably the new Secretary of Labor will get pushed to try to raise that threshold uh, at some point in the next year, year to 18 months. Executive exemption, this comes up a lot. You know, you want to make sure that your people that you're claiming are exempt under this provision are actually, you know, their primary duties managing, uh, a subdivision of the enterprise or a department. Um, you know, and managing too. Managing doesn't mean that you can't get down and do, you know, get your hands dirty and do some of the same work that the people that you're supervising do. But you know, you shouldn't. You know, the people that you have as exempt shouldn't be down there spend the majority of their day down there doing the same work. That's always a bit of a red flag. But their primary duty has to be managing, and they have to customarily and regularly direct work of at least 2 or more full-time employees or their equivalent. So you could have 4, you know, part-time employees, wherever comes up to an equivalent of 2 or more full-time employees. Uh, and then you get, this is another area you see a lot of litigation. A lot of lower-level supervisors don't have the right to hire or fire, but a lot of them you know, do in fact make suggestions to their boss about whether they should hire a particular person, fire them, give them a promotion, make some other change. So if a person, if someone who you know you have listed as exempt or classified as exempt under this exemption, if they can't hire or fire, don't have the authority to do it, you better make sure that they understand that they're clothed with the authority and exercise it to make recommendations to their boss. And so what you can see in certain situations, you know, you can have inconsistency. You can have, you know, a particular manager will listen to the people under him who are exempt supervisors, you know, will follow their lead. Others, you know, don't listen to them. So you can have inconsistency within an organization. So the important thing to do is to make sure you're consistent. You know, it's probably generally not a good idea to give lower level supervisors the authority to hire or fire, but you definitely want to make sure that they understand it's in their, you know, job description. They understand that they can recommend these things, and their boss needs to make sure that they listen and act on what these people say. If not 100% of the time, there's no requirement that they follow every suggestion, but they have to give it, you know, consideration and make sure that happens. Administrative exemptions is another important one. Um, you know, and these are people like, for example, like HR people. We probably have a number of HR people on the attending today, and of course, you know, in the DOL and some of their regulations or guidance, you know, talks about that HR is one of the areas work classifications that they say are exempt just based on the nature of the work. You know, and there are other areas. You know, accounting is an area, purchasing. Um, there are a number of them that are listed. So you've got to, you know, be involved in something non-office or non-manual work that's related to management or general business operations of the company or the company's customers. And your primary duty has to include the exercise of discretion, independent judgment with matters of significance. So that means you don't just follow rules. You have to be able to make decisions, you know, your own decisions up to a point. So, you know, and I've had cases where you got to make sure too on all of these that your job description, the person actually, their actual work matches the job description, because you get people in these cases, they'll claim that, well, they were misclassified because even though their job description, you know, has them down as classified as exempt and has them doing this and that, they really, you know, roll their sleeves up and they do manual work. And so you got to be careful about that. But this is another one, professional exemption. You know, that applies to things like doctors and lawyers and um, pharmacists, people like that that go to school for a long time. It typically doesn't apply to technicians, people that have technical type degrees. Creative professional, that deals with artists and writers and um, people who are creative and create things. It's a separate part of the professional exemption. You've got the computer employee exemption. Um, you've got, I don't want to go through and talk about these, but you've got a number of things that the person has to be doing. It's a pretty broad area of things that the computer employee can do to be exempt. Here they're all listed what the primary duty has to be. You want to make sure if you have computer people there working for you that you have classified as exempt, that they're doing the types of things here that the regulations talk about. Outside sales exemption, this of course doesn't apply to inside sales people. Those people are not exempt, but your primary duty has to be you're out, making sales, you're out outside the facility trying to do sales. You're not. You can still do things internally. You can set up appointments and use the phone and do that, but you're out and about. You're not sitting in the facility all day long. If you do that, you're really an inside salesperson. Then you've got the highly compensated exemption, which is, you paid $107,432 or more per year, and you do at least your customer in the revenue perform at least one of the duties of an exempt executive, administrative, or professional employee. So this is sort of a catch-all area. Who's not exempt? Manual laborers or blue-collar folks like electricians. I've got a cousin that's an electrician who earns a tremendous amount of money every year because he works a lot of overtime. Well, he's not going to be exempt, despite the fact he can make a lot of money, and a lot of these other craftsmen, skilled people do make a lot of money. They're not going to be exempt. And also, too, police officers, rescue workers, firemen, but these type of professions are not. No matter, most of them aren't really highly compensated, but they're not going to. They're always going to be entitled to overtime. They're not going to be put on exempt status. So guarding against misclassification, what do we want to do? Well, we're applicable. We want to make sure the salary basis test is met. We want to make sure that the actual job duties meet the exempt duties test. And that's why it's important to make sure your job descriptions accurately reflect job duties. Job duties do change, and so if they've changed and they move the person out of exempt status, you need to start paying them overtime or controlling, paying them an hourly wage or a salary, and pay them overtime if they work over 40 hours in a week. But always remember, it's not what you call somebody. I know I've had a lot of smaller clients over the years that say, well, this person's got to be exempt because I pay them a salary. Well, that doesn't make you exempt. That's sometimes required to make you exempt, but it's never enough. So you have to reclassify jobs sometimes. And also remote work has changed a lot of jobs. Just the nature of jobs had to be modified so people could work remotely. So look at those jobs and see as we go back to normal or close to normal, if you need to take another look at those. Let's say about pay equity. The Equal Pay Act has been around since 1963. It was one of the first laws, and it requires that men and women in the same workplace be compensated with equal pay for equal work, and it covers really all kinds of compensation, not just wages, but also covers benefits and other perks. A lot of, pretty much more and more states have a state version of the like a mini Equal Pay Act. States like California, New Jersey, and Oregon. You're seeing Maryland. They've tweaked their pay equity laws to cover other kinds of things, not just gender-based discrepancies. So you've got, if you're an employer, you're going to be subject to the Equal Pay Act, but you also may be subject to, a state law that could be more protective of employee rights. So that's why, once again, I can't stress this enough, you need to understand the law of the state where you're operating. That's critically important. Pay equity interactive map. We have some interesting interactive maps on our website. I would encourage you to go look. You can go, click on there, and it brings up information about that state's law. So I urge you to take a look at that. That's certainly a free thing. You don't have to register or anything. You can just go look at it if you want to. But this sort of gives you an idea of what's going on across the country. Now, as an example of a state, I'm a lifelong Tennessean, very happy to live here. But our state has not traditionally had a lot of state laws, a lot of state employment laws. But we have basically the version of the Equal Pay Act in Tennessee. It's called, I'm not sure what it's called. I call it the mini Tennessee Equal Pay Act. But it's got a 2-year statute of limitations. It really is nearly identical to the Equal Pay Act. It just says you've got to, pay men and women the same if they're doing the same work, unless there's some differential. The differentials based on merit system or quantity or quality of production or some reasonable basis, other factor other than sex. So you got this tracks the same language, and you can't retaliate either under this law. What's kind of interesting and makes it different from the Federal Equal Pay Act is you can, if you're a recidivist employer, and you've been sued under this successfully before, if you get sued again and you lose, the plaintiff can get double liquidated damages. And if you have the misfortune to have a third lawsuit and you lose, the plaintiff can recover triple liquidated damages. So it's pretty tough to run into that. That's certainly not the rule under the Federal Equal Pay Act. So steps to ensure compliance. We want to make sure that you always need to be reviewing your compensation policies. We're living in a time where pay equity is one of the hottest issues around. So you want to make sure that you're basing your pay on objective documented criteria. Typically sometimes with management people or higher level employees, there is some subjectivity that comes into play, and that's usually accepted. But try to be as objective as you can, particularly for lower level employees who are high level executives, and try to make sure you have documentation to support why you're paying them what you're paying them. And also, if you have disparities among people who are doing the same or similar work, you need to be prepared to understand, why those disparities exist. You've got to, make sure they're legitimate. Now, there's been a move in some states to prohibit salary history information being asked, of applicants. So you got to be careful about basing, pay based on salary history in a growing number of states. What you want to do is before you get sued, you want to be proactive, and we do a lot of wage and hour audits for clients. You want to get in there and look for red flags. If you see disparities in pay, it's good to go and correct them before you get sued. And if you end up getting sued down the road, I think your efforts to rectify things, will go a long way in helping at least either eliminate or reduce liability. Conducting pay audits. This is something certainly you can do internally. We do this for clients every day, and we can go and go talk to clients. We can keep a lot of the conversations privileged, and we operate across the country and understand state laws in pretty much every state. So a legal safe harbor for employers can certainly help avoid liability. Uh, if you need to change, you need to go ahead and do it. Don't wait. Have formal compensation policies and procedures. Having unwritten rules that you follow. You always need to put things in writing if you can, particularly for things like this. And you want to have safeguards in place. Try to have as few exceptions as possible to pay differentials. You want to make sure that you're not basing it on things, particularly with the growing number of state laws that might infringe on the state law. It's also good to consider having pay ranges or guidelines for a position. A lot of larger companies do that. To have a range so it's all clear what the progression is going to be. All right, remote work and record keeping. We're running out of time here. I'll wind up here just a couple more minutes, Anna. Just give me a couple more minutes. Ordinarily, the rule is under the Fair Labor Standards Act, employers have to pay non-exempt employees who are suffered or permitted to work. That means if you know they're working, even if you didn't tell them to, you got to pay them. So you can't avoid paying them because you're turning a blind eye to it. So you want to make sure that employees understand that they work a particular schedule, and if they want to deviate from that, if they're non-exempt, at least they need to get approval. That's the way you control overtime and unauthorized hours of work. And since there's a trend toward remote working, you need to be more sensitive about this. The whole remote working thing has raised a whole number of issues on how do we, manage performance, productivity, and how do we make sure people are reporting all the hours of work they're doing. So you got, particularly with non-exempt people, this is an issue. The continuous one change that occurred during the COVID pandemic, the continuous workday rule, where people who, unless they clock out for lunch or something, from the time they begin their first principal activity until they do their last, they're, on the clock, except when they clock out. So what has happened with COVID-19 is that got relaxed somewhat because a lot of parents had to teach their kids. They were home, they couldn't go to school, and so a lot of employers would say, well, okay, well we'll schedule you from 7 to 9 or from 11:30 to 3. So anyway, the DOL fortunately showed flexibility there. So make sure if you have someone working remotely that you understand they have some work schedule. It's good to have a formal work schedule if they're non-exempt. When they're working, if they deviate from it, they need to be able to tell you. But the key is you want to make sure that people, whether they're working with you on site or whether they're working remotely, that they're they're reporting all hours work. You need to have written policies regarding that. It needs to be clear in your employee handbook that employees are not to work or report all hours worked and not to work off the clock. I always put, the off the clock is a big issue. I always like to put in handbooks, for example, that employees are instructed to notify, human resources immediately if they're asked to work off the clock for any reason, either before or after. You have to really manage that, and also people need to check their pay, their hours of work, their paychecks, and immediately report any discrepancy. For example, if they're they weren't paid for all hours worked or they worked overtime, you want to deal with that, and also make sure that you have policies that people have to get permission to work overtime, and if they do without permission, you want to make sure you pay them, but they need to be disciplined under your policy and be consistent with that. So anyway, I think we're pretty much out of time here, Anna. I appreciate the opportunity to speak to folks. Happy to answer any questions that you have. So I'm going to go ahead and turn it back over to you.
We do have a couple questions. The first one is, can you clarify arbitration agreements, the FAA, and SCOTUS's recent declining to hear Amazon's appeal?
Yeah, Just in terms of the arbitration agreements, I'm trying to. My train of thought got a little got a little lost here in the presentation. You just need to, you know, we design arbitration agreements for clients all the time where we put in there, you know, that you can't have collective actions, that they, you know, you have to have individual, you know, arbitrations. And so I think you have some states that are, you know, like California, that have been historically hostile to arbitration agreements. We've had, you know, I've done a lot of, have had clients that had arbitration agreements, and across the country, I mean, you run into some states like, remember, Alabama had judges that didn't like arbitration agreements. So you see that periodically around the country. But I think, you know, every time you get a decision that comes back, the Supreme Court, U.S. Supreme Court, has been very clear in enforcing, you know, the preemptive effect of the Federal Arbitration Act. You've got, you know, these transportation worker, you got a transportation worker exception to it, and that's still, you know, I think continuing to be developed by the lower court. So every time you get a new decision that comes out, you have to analyze it and, you know, and consider whether you need to, at least in your future arbitration agreements, go and make changes or even tweak the ones that you have. But I found, I know a number of years ago, I was involved. I had a client that got sued several times in West Virginia, and it was, you know, it was not at that time, at least, a very good place to be sued. So at the time, they didn't have arbitration agreements. They later did, but there's some states where you really need to have them. You know, like in Tennessee, for example, we have, I think, pretty strong, you know, state courts and federal court judges, and you can get employment cases dismissed. But you know, with the class action, the collective action piece, that can get very expensive. And so I think I found, at least in the past, that arbitration agreements will deter a lot of plaintiffs' lawyers from really arbitrating the cases. A lot of times they'll seek a, you know, nominal settlement. So I think the presence of arbitration agreements will very often just nips things in the bud, because the plaintiffs' lawyers don't want to, you know, have to deal with them.
Okay, we do have another question. It is kind of longer, so I chatted it to you as well if you want to read it. But it says an exempt employee requested a day off with the use of PTO for that day. This exempt employee worked 3 hours on Sunday, the start of the week. Does this Sunday work go toward the total 40 hours exempt work, or can the employer have the employee take the agreed upon 8 hours PTO to meet weekly salary?
Well, that's an interesting question. You know, I think you've got to sort of the rule, of course, is that if you have an employee, you know, you can't subtract because they work like a partial day, right? So I think you've got to make sure that, you know, you've got to make sure that they, unless they're taking like a full day off, for example, like if they're taking a full day off for some personal, you know, personal basis like that, that's an exception to the rule that you have to pay them. So let's see, let me read this again. I would say probably, and just as a general good best practice, if you've got somebody who, you know, I would have people, an exempt employee, have them take PTO for the whole day like that if they need to be off, because that, you know, taking a full day off for personal reasons is one of the reasons. If you get into a
The attendee,
you know, partial day like that.
The attendee said that the day off was for personal reasons.
Yeah. Well, if you take a full day off for personal reasons, you don't have to pay for that particular day, even the person's on salary, right? That's the exception. Like here, if you've got PTO for 8 hours or whatever, then I think it's appropriate. at that point for the person to, use their 8 hours of PTO for that day and take off the entire day, as opposed to a partial day.
And then we have one last question if you have time.
Okay, sure.
It says, do you think the DOL will issue a new IC rule under the current administration or just leave it as is since they withdrew the prior final rule?
Well, what I'm thinking they're going to probably do is, you can't rule anything out at this point, but it takes a while to get rules through, and then the Trump administration did, it got frozen and withdrawn. So what they may do is just go back to the default position they had during the Obama administration, which say that 2015 memo that they put out was pretty stringent on laying out sort of this bias or default position that people are employees, unless they use this economics realities test, and it can be applied different ways, but that's been the test that the courts have used for years, and the DOL has used it. But I would say probably there's a lot of discretion in how you interpret things. So I would see probably sort of a move here with investigators, probably just relying on the existing, the way they've looked at it really for years. And, I think there's going to be, a bias in finding, even more so bias in finding that people are employees versus independent contractors, unless the proof is there that the person really is. So I don't think there'll necessarily be a formal rule. There could be. I think they'll just fall back on the Obama administration, the way they interpreted that, during that period, during that 2015 memo.
All right, it looks like that's all the questions for today.
Very good. Well, thanks so much, Anna. I appreciate the opportunity to present for HR Simple. I want to thank everyone for attending today. I hope you learned something. If you have any questions, you can certainly email Anna, and she'll feed those to me, and we'll get back with you with answers. So thank you very much.
Thank you, Greg, so much. We really, really appreciate it. And up on the screen is my email. If you have any additional questions for Greg, I'd be happy to forward them along. I will be sending out the recording and the slides within the next 24 hours. And if you have any questions about anything else, please don't hesitate to reach out to me. The SHRM and HRCI codes are up on the screen as well, so you can make sure you get your credit. Thanks for attending, everyone. Have a great rest of your day.